Hello and welcome to episode 2 of my Employment Law Snapshots. In this episode I'll be looking at a case involving the unfair dismissal of an employee accused of coming to work under the influence of alcohol and robots. Before we get started, I'd like to say thanks to everyone for their very kind words about episode 1. I'm really glad that you enjoyed it. However, for those viewers who provided some so-called constructive feedback on the video, which included suggestions about ensuring that the lighting didn't bounce off my forehead as much, and recommendations for the best brand of makeup to wear, well, I'll see you in court. You'll also see that I've disabled the comments on YouTube, so you'll have to email me directly with your mockery. On the plus side, it'll make it much easier for me to add you to the writ. Anyway, on with the law. This week's case is called McElroy against Cambridgeshire Community Services NHS Trust. In this case, Mr McElroy was employed as a healthcare assistant. After he turned up for work one day, his line manager was told that he smelled of alcohol. The line manager spoke to Mr McElroy and he said that he had drunk a couple of beers the night before. A more senior manager decided to suspend Mr McElroy and he was then referred to the Trust's Occupational Health Department. At this point, it's important to note what the contents of the Trust's disciplinary policy and substance misuse policy were. The disciplinary policy said that being unfit for duty because of drink was an example of gross misconduct. The substance misuse policy said that being unfit through drink meant being incapable of functioning effectively at work. Importantly, the substance misuse policy didn't ban drinking alcohol shortly before coming to work, but it did recommend that employees should avoid it. The disciplinary investigation report said that managers had expressed concern about smelling alcohol on Mr McElroy on a number of previous occasions, but Mr McElroy denied coming to work under the influence. He suggested that people were smelling his aftershave. Importantly, the investigation report also said that nobody had voiced any concerns about Mr McElroy's behaviour or that he'd been acting drunk. Nevertheless, Mr McElroy was told that he had to attend a disciplinary hearing to consider the allegation that he'd come to work under the influence and that this had led to a breakdown in trust and confidence in his ability to carry out his role. The Trust was provided with an occupational health report which had been based on information provided by Mr McElroy about his alcohol consumption. By the time the report was received, there was some uncertainty in the mind of the disciplinary officer. This was because Mr McElroy had given inconsistent explanations for the possible causes of the smell, including the aftershave, garlic and hospital alcohol gel. In addition, the disciplinary officer had become aware that Mr McElroy had been admitted to hospital with an illness which she knew could be associated with excess alcohol consumption. As a result of this uncertainty, Mr McElroy was asked to attend another occupational health appointment, but he refused. Eventually, Mr McElroy was summarily dismissed for gross misconduct. Although the letter dismissing him referred to the original disciplinary allegation of coming to work under the influence, it also referred to the fact that he'd failed to follow a reasonable management instruction when he was asked to go to the second occupational health appointment and refused. Mr McElroy brought an unfair dismissal claim. The Employment Tribunal decided that he had been unfairly dismissed. As part of the decision, the Employment Tribunal said that it was reasonable for the Trust to find that Mr McElroy had come to work smelling of alcohol, based on the evidence that it had. The Tribunal also said that it was reasonable that the Trust had wanted Mr McElroy to go to another occupational health appointment, and for the Trust to find that his refusal was unreasonable. However, the reason why the dismissal was unfair was because the Tribunal said that a reasonable employer wouldn't have concluded that Mr McElroy was unfit for duty, because there was no evidence that he'd been incapable of functioning effectively at work. The Tribunal focused on the strict wording of the Trust's two policies, which essentially said that an employee had to be incapable of functioning effectively at work due to alcohol, and there was no evidence to support this. The other mistake made by the Trust was the fact that the reason given for his dismissal also included his refusal to attend the second occupational health appointment. However, the refusal hadn't occurred when the disciplinary process had started, and therefore Mr McElroy hadn't had this allegation formally put to him before the disciplinary hearing. In addition, the substance misuse policy said that a refusal to attend an occupational health appointment wouldn't normally be a ground for disciplinary action. Therefore, the tribunal decided that a reasonable employer wouldn't have found an employee guilty of this sort of allegation when it hadn't been properly drawn to his attention during the disciplinary process. So, the moral of the story is that employers must make sure that they look at their relevant policies closely when carrying out a disciplinary process, to make sure that the allegations against an employee are accurate and sit comfortably with the wording of their policies. Finally, when any new potential allegations arise during the disciplinary process itself, it's important that they're drawn to the employee's attention properly and before any disciplinary decisions taken. This week, I'm becoming increasingly aware of the incursion of robots and artificial intelligence into the world of employment. Firstly, a hotel in Japan is reportedly going to be partially staffed by human-like robots. The hotel's due to open in a few weeks, and apparently there'll be 3 uniformed receptionist robots, a handful of porter robots and cleaning robots. Having looked at a couple of photographs on that newfangled interweb, the robots are incredibly lifelike. According to various reports, the hotel will also be staffed by some human beings, which is nice. To make matters worse, if you're worried that your job might soon be replaced by a robot or some other science fiction based entity, why not have a look at the website link below, which predicts the likelihood of your job being done by a machine in the future. You'll no doubt be delighted to hear that lawyers only have a 3.5% chance of becoming automated in the future. I can hear the cheers from here. When I told the current Mrs. Tibble the good news, she said that it was a shame, bearing in mind, and I quote, that I could already pass myself off as a robot with my shiny C3PO forehead. Harsh, but true. Thanks for watching. I hope you enjoyed our second episode. If you want to subscribe to our YouTube channel for more updates, click here. If you want to follow us on our fantastic Twitter page, which gives you a daily heads up about everything employment law related, click here. Or if you just want any more information or help, please go to our website by clicking here. Also, all of the links are below. Once again, thanks for watching and see you next time.